of Criminal Procedure, Chapter 3, Disqualification of Court Officers, Article 17. Where there is one of the following circumstances in the case before him, a judge shall disqualify himself from the case concerned on his own motion and may not exercise his functions. 1. Where the judge is the victim of the offenses charged in the case concerned. 2. Where the judge is or was the spouse, blood relative within the 8th degree of kinship, relative by marriage within the 5th degree of relationship, family head or family member of the accused or of the victim. 3. Where the judge has been engaged to the accused or the victim. 4th, where the judge is or was the statutory agent of the accused or the victim. 5th, where the judge had acted as the agent, defense attorney, or assistant of the accused, or as the agent or assistant of the private prosecutor, or of a party in the supplementary civil action. 6. Where the judge had acted as the complainant, informer, witness, or expert witness. 7th, where the judge had exercised the function of the public prosecutor or judicial police officer. 8th, where the judge had participated in the decision at a previous trial. Article 18. A party may make a motion to disqualify a judge in one of the following circumstances. 1. Where circumstances specified in the preceding article exist and the judge has not disqualified himself from the case concerned on his own motion. 2. Where circumstances other than those specified in the preceding article exist, which would justify a view that the judge may be prejudiced in the exercise of his function. Article 19. A party may, at any stage of the proceedings, motion to disqualify a judge in the circumstances specified in subparagraph 1 of the preceding article. A party who has already made a pleading or a statement on the substance of the case may not subsequently make a motion to disqualify a judge in accordance with subparagraph 2 of the preceding article, unless the circumstances specified in the said subparagraph occur or are discovered subsequent to the pleading or statement on the substance of the case. Article 20. A motion to disqualify a judge shall set forth the reasons of disqualification in writing and be filed with the court to which the judge belongs, except when such a motion is made on the trial dates or during examination, where it may be made verbally. Reasons for the motion to disqualify a judge and the facts required of by the proviso of the second paragraph of the preceding article shall be set forth and explained. A judge against whom a motion of disqualification is made may file a written opinion. Article 21. A motion to disqualify a judge shall be determined by a ruling rendered by a panel of judges of the court to which the judge's sole motion belongs. When a quorum of the panel is not present, such a ruling shall be made by the president of the court. Where it is impossible for the president to render such a ruling, it shall be made by the court which is immediately superior to the court to which the judge's sole motion belongs. A judge against whom a motion of disqualification is made shall not participate in the ruling specified in the preceding paragraph. If a judge against whom a motion of disqualification is made considers that such a motion is well grounded, he shall thereupon disqualify himself without a ruling being made. Article 22. Where a motion is made for the disqualification of a judge, the proceedings shall be suspended except for making an emergency decision, or in the case where the motion is based upon subparagraph 2 of Article 18. Article 23. An interlocutory appeal may be made against a ruling that dismissed a motion to disqualify a judge. Article 24. A court that has jurisdiction to hear a motion to disqualify a judge or the president of the said court shall sua sponte make a ruling requiring the motioned disqualification. If the said court or its president considers that the reasons exist which require the judge to disqualify himself on his own motion, a ruling made in accordance with the preceding paragraph does not need to be served. Article 25. Provisions in this chapter relating to the disqualification of a judge shall apply mutatis mutandis to a court clerk or interpreter, provided that the previous service as a clerk or interpreter in a lower court is not a reason for disqualification. The disqualification of a court clerk or interpreter shall be determined by a ruling rendered by the president of the court to which the clerk or interpreter is attached. Article 26. The provisions of Article 17 through 20 and Article 24 concerning the disqualification of a judge shall apply mutatis mutandis to a public prosecutor, a public prosecutor investigator, or a clerk who deals with public prosecuting affairs, provided that the previous service as a public prosecutor, public prosecutor investigator, a clerk or an interpreter in a lower court is not a reason for disqualification. A motion to disqualify a public prosecutor, a public prosecutor investigator, or a clerk specified in the preceding paragraph shall be made to the chief prosecutor concerned or the prosecutor general for appraisal and decision. A motion to disqualify a chief prosecutor shall be made to the chief prosecutor of the immediately superior public prosecutor office or to the prosecutor general for appraisal and the decision. The same rule shall apply if there is only one prosecutor.